while we're disappointed with the decision, we strongly believe the court has an important role to play in upholding the rule of law. That's why we referred this case to the court system in the first place. Our government always said this case would likely be heard before the Supreme Court, and in fact, we asked the federal government to join us in a direct reference to the Supreme Court of Canada. We continue to believe that we have the authority and the responsibility to protect our environment and economy, and so we will be exercising our right to appeal to the Supreme Court of Canada. The aim of this regulation is to protect our coast and local jobs and wildlife from the catastrophic effects of the diluted bitumen spill. And that is what it is aimed at. We believe that we have the right and authority to regulate substances that are brought in, including through interprovincial pipelines, which is where the court and our position parted company in this decision. We would like clarification from the Supreme Court of Canada on that question. And we think it's critically important as elected officials in British Columbia, elected to protect British Columbians' interests, especially economic interests, to ensure that we have the protections in place to prevent a catastrophic spill. I mean, it was our hope to go directly to the Supreme Court of Canada. We asked the federal government to go directly with us, and the only way that we could do that was with a joint reference with the federal government on these questions, and they declined to do that. The highest court that we could go to, we have the ability to go to the BC Supreme Court or the Court of Appeal. We went to the highest court we could, which was the Court of Appeal, because we believe we need clarity on this as much as everybody does, and as soon as possible. And I'm certainly grateful for the Court of Appeal for considering these reference questions and returning a decision in a timely way for us.